Today we explore the landmark Supreme Court case of D.K. Basu versus State of West Bengal, 1997, a turning point in India's legal landscape regarding custodial violence and the protection of fundamental rights during arrest and detention. This judgment not only addressed the alarming rise in custodial deaths and torture, but also laid down mandatory guidelines for all police agencies, both central and state. The court's aim was clear: to safeguard Article 21, which guarantees the right to life and dignity, and Article 22, which protects the rights of arrested persons. Let's journey through the background, the case, and the powerful guidelines that continue to shape law enforcement in India. In the 1980s, India witnessed a disturbing rise in reports of torture, abuse, and deaths in police custody. Newspapers frequently highlighted these incidents, yet accountability for police officials was rare. Despite existing laws like the Criminal Procedure Code and constitutional protections, there were no clear procedural safeguards for arrest and detention. India had even signed the UN Convention Against Torture in 1997, committing to prevent such abuses internationally. However, custodial violence remained widespread, exposing a gap between law and practice. This context set the stage for a much-needed judicial intervention to protect basic human rights. The case began when D.K. Basu, then Executive Chairman of Legal Aid Services West Bengal, wrote a letter to the Chief Justice of India in August 1986. He highlighted repeated newspaper reports of custodial deaths and torture, urging the Supreme Court to frame guidelines and compensation rules. The court treated this letter as a public interest litigation, PIL, and issued notices to all state governments and the Law Commission of India. Another letter from a ligar describing a specific custodial death was tagged with this PIL, showing that the problem was not isolated but systemic across the country. Case, officially titled D.K. Basu vs. State of West Bengal, Air 1997 SC 610, was heard by Justices A.S. Anand and Kuldip Singh. As a public interest litigation, it focused on custodial violence, torture, and deaths in police custody. The Supreme Court had to answer crucial questions: how can torture and deaths in custody be prevented? What procedural safeguards must be followed during arrest and detention? And can the state be held vicariously liable with compensation ordered for violations of fundamental rights? These questions would shape the future of police accountability in India. Supreme Court connected custodial violence to several constitutional protections. Article 21 guarantees the right to life and personal liberty, including the right to live with dignity, free from torture and inhuman treatment. Article 23 protects against self-incrimination, while Article 22 ensures the right to be informed of the grounds of arrest and to be produced before a magistrate within 24 hours. Article 32 allows individuals to move the Supreme Court for enforcement of fundamental rights. Statutory backing came from the Criminal Procedure Code, especially sections dealing with arrest and detention, reinforcing the need for procedural safeguards. Supreme Court's objectives in the D.K. Basu judgment were clear and far-reaching. The primary goal was to prevent torture, assault, and deaths in police custody. The court sought to ensure transparency and accountability in every arrest and detention, providing clear national-level guidelines for all police forces. Importantly, the judgment recognized that violations of fundamental rights would give rise to an enforceable right to compensation from the state, in addition to criminal and civil liability. This marked a shift towards a human rights-oriented approach to custody jurisprudence in India, emphasizing the dignity and safety of every individual. One of the first guidelines mandated that all police personnel involved in arrest or interrogation must wear accurate visible name tags and designation badges. Additionally, particulars of all officers handling interrogation must be recorded in a register. This measure helps the arrestee and the courts identify specific officers in case of abuse or misconduct, creating a traceable chain of responsibility. By making police actions more transparent, this guideline aims to deter misconduct and ensure that accountability is not lost in the system. The arresting officer must prepare a written arrest memo at the time of arrest, stating the date, time, and place of arrest. This memo must be attested by at least one witness, either a family member of the arrestee or a respectable person from the locality, and countersigned by the arrestee. This process prevents secret arrests and manipulation of arrest times, providing crucial evidence for courts to check illegal detention. It's a simple yet powerful safeguard to protect the rights of those taken into custody. Every arrested person has the right to have one friend, relative, or person interested in their welfare informed about their arrest and place of detention. If the relative or friend lives outside the district or town, the police must notify them through the legal aid organization and local police station within 8-12 hours. Importantly, the arrestee must be clearly told at the time of arrest that they have this right. These steps ensure that no one is held incommunicado and that families are not left in the dark about their loved ones. Specific entry must be made in the station diary at the place of detention, detailing the arrest, the name of the friend or relative informed, and the particulars of the police officials having custody of the arrestee. Copies of all relevant documents, such as the arrest memo and inspection memo, must be sent to the jurisdictional magistrate. The magistrate is responsible for checking whether these safeguards were followed when the arrestee is produced. This oversight mechanism strengthens the accountability of the police and protects the rights of the detained. At the time of arrest, an inspection memo should record all major and minor injuries on the arrestee's body, signed by both the arrestee and the arresting officer, with a copy given to the arrestee. Furthermore, the arrestee must be examined by a trained doctor every 48 hours during custody, with examinations conducted by a doctor from a panel approved by the Director of Health Services. These medical safeguards create an independent record of the arrestee's condition, help detect torture or ill treatment early, and provide crucial evidence if abuse occurs. Arrestee must be allowed to meet their lawyer during interrogation, though not necessarily throughout the entire process. This right, rooted in Article 22(1), ensures that the arrested person can consult and be defended by a legal practitioner of their choice. Allowing access to a lawyer prevents completely incommunicado interrogations, where torture is most likely, and encourages the police to follow lawful methods of questioning. This safeguard is vital for upholding the rule of law and protecting the rights of the accused. Every district and state headquarters must have a police control room. The officer causing the arrest must communicate the details of the arrest and place of custody to the control room within 12 hours. This information should be displayed on a notice board at the control room, allowing families, lawyers, and courts to verify the place of detention quickly. This measure prevents the disappearance of arrestees and strengthens transparency in the criminal justice system. Supreme Court clarified that an arrestee retains all fundamental rights except those lawfully restricted. Degree methods, torture, rape, and custodial deaths are direct violations of Article 21. The state can be held vicariously liable for wrongful acts of its employees, and victims or their families are entitled to monetary compensation ordered by constitutional courts for violations of fundamental rights. This remedy is in addition to criminal prosecution and civil suits, reinforcing the seriousness of custodial abuse and the need for accountability. DK Basu guidelines influenced later amendments to the Criminal Procedure Code in 2008, incorporating safeguards like mandatory arrest memos, information to relatives, and production before a magistrate with documentation. The Supreme Court followed up with several subsequent orders in related cases to push for implementation. The Law Commission's 113th report on injuries in police custody was also considered, recommending evidentiary presumptions against police in custodial violence cases. These developments show the lasting impact of the DK Basu judgment on India's legal system. Despite the DK Basu guidelines, custodial deaths remain a serious problem in India. NHRC data from 2020-22 shows thousands of custodial deaths in just 2 years, highlighting persistent structural issues. Problems in implementation include non-recording of injuries, delayed or no intimation to families, weak magistrate scrutiny, and lack of independent investigations into custodial deaths. These ongoing challenges underscore the need for continued vigilance and reform to ensure that the spirit of the DK Basu judgment is fully realized. DK Basu guidelines transform abstract human rights into concrete checklists for every arrest. They empower lawyers, judges, families, and human rights groups with specific points to verify, such as name tags, memos, medical reports, and diary entries. These guidelines provide a strong legal basis to challenge illegal detention, torture, and fake encounters. Most importantly, they reinforce that the procedure established by law under Article 21 must be fair, just, and reasonable, not arbitrary. Their continued relevance is a testament to their foundational role in protecting human dignity. To recap, DK Basu v. State of West Bengal 1997 was a public interest litigation on custodial violence. The Supreme Court held that custodial torture and deaths violate Articles 21 and 22 and that the state is vicariously liable with compensation as a public law remedy. 11 operational guidelines were laid down covering police identification, arrest memos, the right to inform relatives, medical safeguards, magistrate oversight, access to lawyers, and police control room transparency. These guidelines remain a cornerstone of human rights protection in India's criminal justice system.